All right, welcome back. Let me just set up the timer here. Hold on. Apps timer. So last class we were talking about our last Daily 10 lecture. We were talking about um, the difference between there we go. The difference between the civil law system and the common law system. So, civil law system is what a lot of the world uses, which is just statutes, just constitutions, just black letter law, things typed out, written down, and agreed upon by legislatures. And the solution for any sort of inconsistent rulings by judges is to just write a new law. Okay. So they usually have many more laws than common law systems have. Um, Common law systems, however, is all the same things, the black letter law, plus the interpretations by different courts, by judges. That becomes case law, and it's just as binding as what the legislature does, right? So we have two systems, two sources of law in the US. One is the judicial system makes interpretations of law, which become as strong as law, and the laws themselves, right? So let me talk a little bit about why or how powerful those interpretations can be, and why I say they're essentially as strong as law. Um, let's back up to right around the time of the Civil War, or just after the Civil War, when the US was really expanding economically. Um, this idea that we had in kind of the economic sphere was of the free market. We had this philosophy of laissez-faire, if you've heard of that. Free market economy, though, was in vogue. And it was this idea that businesses and corporations and individuals had unfettered rights to do business as they pleased. If it made money, they were allowed to do it, right? Um, this led to things like monopolies, to lots of political corruption, to environmental pollution, to hazardous working conditions, to labor management disputes. And most people were really sad about how powerful our companies were becoming. Now, the oil tycoons loved it, right? And so they were fighting against anyone who said, we should have some regulations, shouldn't we? Um, but the state governments, their job was to protect the citizens. They were being elected by the regular citizen. And so the politicians, although, they were getting lots of money from these oil tycoons, it was really hard to have that one person elect them. They needed to be in touch with the common man as well, and at least be seen to be fighting for them, right? So, the first case that I want to talk about is a case called Lochner versus New York. It's like the Loch Ness Monster, right? Lochner, Lochner. This is a 1905 case. And New York was trying to help bakers. The Bakers Union essentially said, hey, bakers work too long. We have to be up really, really early baking the bread. Then we've got to sell the bread all day. And we have to be up really, really late, like making the dough and letting it rise and whatever else, right? And so we had these really long hours as bakers. And so the New York passed a law that said, okay, we're going to limit bakers' work hours to 10 hours a day, 60 hours a week maximum, right? And, the bakeries, the rich baker tycoons, were like, wait a minute. We don't want this. So we're going to sue and appeal to the Supreme Court. And the Supreme Court sided with the bakers um, against New York, right? And basically said the bakers shouldn't be protected by the state because the bakers have freedom to contract, right? Bakers are adult men. They can negotiate their own working hours. If they don't want to work 26 hours a day, they can get a different job or work for a different bakery, right? Of course, there weren't any different bakeries that were doing less hours, but that aside, um, the Supreme Court said we're interpreting the Constitution in a way that says states can't infringe upon an employee's power to contract. And so what were they interpreting? What laws were they interpreting? The Supreme Court said, we're looking at the Fifth Amendment and the 14th Amendment, which both say no person shall be deprived of life, liberty, or property without due process of law. And if you just pass a law that deprives them of their ability to contract and negotiate their own working hours, you are taking away their liberty and life and property and whatever else, right? And there's no process for them to be able to negotiate their own working hours. So that was the law under Lochner, and that was a law for many, many years. And people fought against it, different states fought against it, but they always lost. The Supreme Court always said, no, Lochner, right? Or the court said, no, Lochner. The Supreme Court already told us, right? Well, it came back up again in a case called Atkins versus Children's Hospital. This is a 1927 case where Washington, D.C. tried to set a minimum wage for children and for women. And the Supreme Court said, I see what you're doing. We said our Lochner decision was based on the idea that these men had power, they could negotiate their own contracts. And you're saying kids and women don't have the same kind of powers. But whatever, we don't care. Freedom to contract, Fifth Amendment, 14th Amendment, it's all there. You can't limit the how much children's hospitals can pay children who work there, right? And so the kids should negotiate their own salaries. Done. Well, this set off a lot of upset around the country, and a lot of states started passing laws that limited things and protected their citizens. So labor relations laws, protections against discrimination, protections for the environment, protections for just societal values, and so on and so forth. And this case, it's a Washington case called West Coast Hotel Company versus Parrish. 1937 finally got to the Supreme Court. It was a Washington case where Washington was trying to set a minimum wage law again, and the country was just in turmoil. Lots and lots of states were trying to pass these laws, and they kept getting shut down because the state Supreme Courts were all pointing up to Lochner and saying, look, the federal Supreme Court of the United States of America says that you can't regulate business, right? You can't protect the environment. You can't protect workers' rights. None of that, right? And Roosevelt, the president at the time in 1937, he was like, he saw the way the wind was blowing. He saw how angry everyone was about this and how all the states were passing all these laws in defiance of the Supreme Court. And so he said, you know what, Supreme Court, if you don't go with the people and overrule yourself on Lochner, I'm going to pack the court. The court has 9 justices. I'm going to make it 15 justices and add 6 more justices that are loyal to me. And then everything you rule on is going to be the way I want it to be ruled on, right? Well, the Supreme Court did not like this, right? But there's nothing in the Constitution saying how many Supreme Court justices there are, right? And so technically, Roosevelt could just pack the court. And so to save the independence of the Supreme Court folded. It was Justice Roberts at the time, which is kind of coincidental because our current Chief Justice is Justice Roberts. This is a different Justice Roberts. He switched sides and he voted in West Coast Hotel versus Parrish, this Washington state minimum wage case. He voted with the minority and overruled all the Lochner era cases. And their interpretation, what they interpreted was, well, yes, the Fifth and the 14th says this whole due process thing, right? But there's also another law, or another amendment in the Constitution. It's called the 10th Amendment. And it said that all the powers that are not delegated to the U.S. Constitution, not delegated to the federal government, or prohibited to the states, are reserved to the states. And one of those reserved powers is police power. And we think that this kind of regulation is the police power of the states. And so we're going to overrule Lochner by our interpretation of what the 10th Amendment means. And the 10th is after the 5th, so therefore it has more power than the 5th. What is their interpretation? Right? So the laws didn't change, just which ones had more precedence and priority and power based on interpretation. That's what changed. And so ever since this law, suddenly states can regulate things and the free market can have regulation again as of 1937. Okay, look, that's my 10 minutes. I'll talk to you guys next time.